Good morning and welcome to the Supreme Court of the United Kingdom. Today we're hearing the appeal from the English Court of Appeal in the matter of Bott & Co. Solicitors Limited against Ryanair DAC. The main issue in the appeal is whether the appellant Bott & Co. can claim an equitable lien in relation to their charges when pursuing delay claims against the respondent airline. I am Lord Briggs. Sitting with me this morning are Lady Arden.
Good morning.
Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lady Rose.
Good morning.
The counsel for the appellant are Nicholas Bacon, Queen's Counsel, and Ben Smiley, and from the respondent, Brian Kennelly, Queen's Counsel, and Tom Coates. We will be taking a short break at or about 11:45 at a moment of Mr. Bacon's choosing, and I'll now call on Mr. Bacon to begin his submissions.
Well, a very good morning to my lords and my ladies. The test as to whether a solicitor is entitled to an equitable lien, as it's been described, is that set out at paragraph 45 of Gavin Edmondson, Solicitors Limited and Haven Insurance, the decision of the Supreme Court reported in 2018. The test, and I'll take my lords and ladies to the test in a moment, is one, was there a sufficient contractual entitlement of the solicitor against the client to form the basis of an equitable lien over the relevant monies, usually funds recovered from or owed by a defendant to the clients. Secondly, that the recovery of those funds and or the claimant's or client's entitlement to the funds owed their creation to a significant extent to the solicitor's services provided under the relevant fee agreements. And lastly, in the absence of collusion, that the defendant had notice or knowledge of the solicitor's interest in the debts. And I'm going to spend a large part of my submissions in Gavin Edmondson and in the decision of the Court of Appeal below. For your reference, Gavin Edmondson begins at page 811. The test to which I have summarised at paragraph 45 appears at page 827. I referred to the equitable lien in my very brief opening as how it has been described. At paragraph 35 of the Edmondson decision, which is page 824, there is the reference to Barker against St Quintin, which shows better than any other that the equitable lien operates by way of security or charge. The passage at paragraph G on page 824. The lien which an attorney is said to have on judgment, which is perhaps an incorrect expression, is merely a claim to the equitable interference of the court to have that judgment held as security for his debt. Now, my lords and my ladies, we contend that Bott, if I may call my client Bott, has a sufficient contractual entitlement against the client to form the basis of an equitable lien. The CFA, conditional fee agreement terms, provide for that contractual entitlement. The recovery of the damages that have been paid by Ryanair was plainly secured through the instrumentality of Bott to a significant extent. Indeed, but for Bott's involvement, and in particular the letter before action, nothing would have been recovered. The work of advising Bott's clients on the claim and in settling and issuing a letter of claim under the CFA is litigation services, and it's been recognised as such in the cost regime with which we have all become pretty familiar over the last 20 years. Gaynor, a case which I will refer to shortly, was wrongly decided, and I shall explain why in the course of my submissions. And there is no dispute in this case that Ryanair had notice of Bott's interest and its entitlement to payment. The question for this court primarily is whether the Court of Appeal was right in its analysis of what litigation services are, whether a boundary, as I've called it in the submissions, of litigation services is required, and whether the court was right to determine that the work that was undertaken by Bott fell outside the definition of litigation services. The Court of Appeal decision is in the core bundle, the key bundle. It's at page 97. And at page 104, at paragraph 34, Lord Justice Lewison, in giving the judgment of the court, said the main issue under this head on this appeal concerns the limits of the right. And the court concluded that Bott did not have a right to ask the court to intervene in order to protect the solicitors' entitlement to the fees that they had incurred in securing the recoveries. It's pertinent to observe that the court was, it appears, proceeding on the basis that the test to which I have referred, and which is set out in the Government Robinson decision, paragraph 45, needed limits, required further amplification by way of limits. Even in the context of a case where the work undertaken was, as a matter of fact, we say, plainly instrumental in the recovery of the fund. The Court of Appeal decision, paragraph 59, is really the nub of the conclusions reached by Lord Justice Lewison, page 110. In my judgment, therefore, where Bott simply writes a letter of claim, I might say that it is loaded to some extent, this passage, and I'll come back to the work involved, but where Bott simply writes a letter of claim or assists a client to complete the online form, and the claim is paid in response to the letter of claim, it is not entitled to an interest in the compensation that equity will protect. I will reject this ground of appeal. And what I would like to do this morning, my lord and my ladies, is to deconstruct that conclusion and demonstrate that it is fundamentally flawed with the greatest respect to Lord Justice Lewison. The principle underpinning, or the point underpinning, the premise underpinning his conclusion, is that the work that was undertaken was not litigation services. And it appears from paragraph 58, the preceding paragraph, that there were really three factors or grounds which led him to that conclusion. If one looks at paragraph 58, he begins by saying that a claim under the regulation is, quotes, largely mechanical and formulaic. And I'll come back to these points in more detail in a moment, but that is the first point. The second is that that the compensation is fixed. and it does not need to be evaluated. That's in the third or fourth sentence of that passage. And then lastly, the third point seems to be that the vast majority do not need court proceedings. And it's those three factors which lead him to conclude that it couldn't have been the intention of this court, and more particularly the judgments of Lord Briggs, that such work would fall within the equitable principles to which we're concerned. Now, there are three central planks before coming to those three factors. There are three central planks of my appeal. The first is that the Court of Appeal erred in its approach to the question of whether the work was litigation services. The second is that the imposition of a boundary was in any event something that this court, the Supreme Court, thought unnecessary. And there was very good reason for that, as I shall explain. And the third is that the Court of Appeal erred in distinguishing the nature of the work undertaken, just from a factual point of view, from the work that was undertaken in the Government-Edwardson cases. This latter point, of course, is not strictly necessary for me to argue if I'm right about litigation services. Because even on the Court of Appeal's approach, if litigation services are provided, then relief through the equitable principle can be secured. Now, I turn then to litigation services, and I should at the moment, at this point, apologise to my lord and to my ladies about the flurry of activity yesterday and the delivery of a further set of authorities. But as so often happens, regrettably, in the course of my preparation, it did occur to me that there was a fundamental point that none of us, certainly on this side, or indeed my friend's side, or indeed in the court below, considered, and it's a pretty fundamental one, arising out of the Court of Appeal's judgment in Canary and Gray and the subsequent upholding of that decision in the House of Lords. And you should have a supplemental bundle including the Canary and Gray judgment and in both the Court of Appeal and the House of Lords. I'll come to the judgment in a moment, but I hope that you have them, and I'll pass on my apologies. I know too that Mr. Kennelly afforded some further authorities, and I dare say on his behalf, I pass on his apologies likewise for those two subsequent authorities. Now, a paragraph...
You really don't need to apologise, either of you. The court is always grateful, even if it comes late, to have additional relevant authority produced.
Well, thank you, my lord.
No party should feel inhibited from doing so.
Thank you, my lord. Paragraph 53 of the Court of Appeal judgment, which is at page 109. The last sentence of that paragraph, Lord Justice Lewison says, "It seems to me that the services that will attract the protection of equity are services of the kind that a solicitor would perform in conducting litigation or contemplated litigation." We agree, and certainly I agree on behalf of Bott, that where a solicitor performs litigation or conducts contemplated litigation, plainly the principle should apply and the solicitor should have the protection afforded by the principle. The problem with the Court of Appeal's subsequent analysis is having arrived at that point was to say that the work that we were doing, that Bott was doing, fell outside of that category of work. Ignoring any gloss of any kind overlaid by cases like Gaynor, which I'll come to shortly, we say that a solicitor, that the services a solicitor provides and performing and conducting litigation or contemplated litigation would unquestionably include determining whether a claim can be brought at all, and taking instructions on the claim, investigating the claim, interrogating it, drafting a letter before action on instructions and dispatching it to the opponent. Of course, all of that work falls within the definition of conducting litigation or contemplating litigation, certainly the latter. And there are a number of reasons for that. Many that we would submit are self-evident and need hardly to be stated. If a client goes to a solicitor, he does so, or she does so, for advice in respect of a potential legal claim in the context of which we're concerned. They attend in contemplation of potentially taking proceedings against another party. The first thing the solicitor will do is consider the papers and advise whether there is a legal claim or whether there appears to be a legal claim. And the claim will develop in the course of time, depending on its nature and the level of work required to give the advice. Sometimes that work is significant and sometimes it's not significant, but the principle's the same. Pre-issue work of this kind often involves taking statements and investigating all sorts of inquiries, all in advance of a letter before claim. Without the work, there can be no litigation. And letters of claim I'll look at in more detail shortly, but broadly speaking, they are an essential ingredient in my submission of any litigated or non-litigated claim. It is the instrument through which the client's claim is first articulated, and very often, as we know from practice, they're often interrogated and trawled through by the courts. Sometimes the letters can be very short, but sometimes they can be very long. Either way, they serve precisely the same purpose. A solicitor preparing a letter of claim is self-evidently work of the kind that the solicitor would perform in contemplated litigation cases. And indeed, a solicitor conducting a contemplated litigation would see it as her duty to prepare a letter of action before launching proceedings. The profession is required to do so by the court rules, as we know, and I will turn to the practice directions and the practice and the PAPs, so they've been called later. As that being the case, we say fundamentally that that applying the last sentence of paragraph 53 on page 109, the work undertaken by Bott falls squarely within the rubric of what Lord Justice Lewison was there saying. But what he does, though, and this is where, with respect to the Court of Appeal, it went seriously wrong, is that he sought to then limit or confine the definition of litigation services in a way which we submit is obviously wrong. And he does so, first of all, by referring to the definition in section 119, at paragraph 54, he refers to the definition of litigation services in section 119 of the Courts and Legal Services Act, where he cites it at the top of page 110 of the bundle. What he doesn't do, I'm afraid, is consider the definition of proceedings in section 58 of the Courts and Legal Services Act. The definition if I could just turn to the authorities bundle, the first bundle, so it's page 649 for the definition of proceedings under section 119, first of all, page 649. You should find the Courts and Legal Services Act, section 119, the interpretation section. And about a third of the way down the page is the word proceedings, and it simply means proceedings in any court. If Lord Justice Lewison was working on the basis that proceedings was limited to court proceedings, it might explain why he he ended up where he got to, but it's not clear that he did. But if he had done, he would have been wrong to have done so, because section 58, which appears at page 645 of the bundle, dealing with conditional fee agreements, modifies the definition of proceedings in section 119 to make it clear that despite the express definition that it's proceedings in any court, but it's not actually proceedings in any court at all. It's proceedings, not just proceedings in any court, but in any sort of proceedings for resolving disputes. And we see that in section 58, subsection 4 on page 646, 58A. So page 645 is 58A, page 646 is 58A4. Where we see that in section 58 and this section, and in the definitions of advocacy services and litigation services, so it specifically draws the new definition in as they apply to their purposes. Proceedings includes any sort of proceedings for resolving disputes, brackets, and not just proceedings in a court, close brackets. One might just open another bracket saying, as defined by section 119, close brackets, whether commenced or contemplated. Now, this is clearly an expansion of the definition of litigation services, varying the definition in section 119. And so it is not just proceedings or contemplating proceedings arising out of litigation in the court context to which litigation services apply. It's any form of litigation. Now litigation is naturally aligned to, I would submit, taking legal steps. But litigation itself is not separately defined, but we know what it means when we see it. It is taking legal steps, we would submit, and it's the taking of legal steps that do not necessarily have to arise in the context of court proceedings that is covered specifically by section 58. And I might just add here, my lord, we don't have it in the bundle, but section 58AA, for your note, deals with the new breed. My lord, Lord Legate, yes.
When we're asking what litigation services means, don't we have to have in mind what is the purpose for which we're asking the question? And it would be helpful to have an explanation of that. I mean, my understanding is that in this Act, the main purpose for which the question is asked probably explains why it's defined as court proceedings. Is in the context of what activities are reserved to solicitors or certain other professional people, and which other lay people are not allowed to do. Maybe in the context of conditional fee agreements, the purpose is a bit different from that. I'm not sure, because I'm not very familiar with how that works. But you always have to have in mind, don't you, why am I asking whether something is litigation services?
My lord, yes, you do. And as my lord infers, the Act, so the Courts Legal Services Act, covers a variety of different topics, one of which is the creation of legitimate forms of retainers that can be entered into by solicitors on a conditional basis. Section 58 is the statutory route through which Parliament has determined that solicitors, not just solicitors, but others providing litigation services, including claims management companies, can offer services on a no-win, no-fee type basis. And I'm going to come to that in a little bit more detail, but that is why it is actually very important in the context of these claims, which are all underpinned by conditional fee agreements, and which underpins the principle to which the security, the equitable charge in these cases has set to arise, namely the provision of access to justice in circumstances where representatives are prepared to pursue claims in the event that they are paid only in the event that there's some success, that one has to tie the principle of the equitable charge to the nature of the retainer. And that's why it's critical to understand what the remit of litigation expenses was intended, the litigation service was intended to cover in this context. We do have an expanded definition in the context of conditional fee agreements permitted under Section 58. And it's the taking of any legal steps, we would submit, that's covered by the definition of litigation services within the meaning of Section 58A4. I mean, you can equally cover taking steps to enforce claims arising out of any sorts of proceedings. The word sorts of proceedings is used. And they're wide enough to cover employment tribunals, which oddly enough is non-contentious business, bizarrely enough. Arbitration, proceedings before independent assessors, and possibly proceedings before a mediator. Proceedings in respect of statutory compensation schemes would also fall clearly within the rubric of Section 58. And indeed, before my Lord Legate raised his arm, I was just about to refer to Section 58AA, which is the section introduced to do with damages-based agreements. It's not before the court, but it's a good example of the fact that litigation services under Section 58 is much broader than what appears to be Lord Justice Lewison's thinking. Section 58AA, which deals with damages-based agreements, covers not just solicitors and other representatives, but it covers claims management companies specifically. My lady Aunt.
Yes, isn't there another distinction here? When you're dealing with companies which operate through online platforms, because many airlines do, you've got to have an online process of making the claim. And you have such a process. I mean, it could be with a railway company, anything. You've got a claim against them, they provide a form, you fill it in and send it in. Then if they don't accept it, then there's a little system usually built in for resolving that dispute. Isn't there a distinction between the process of putting the claim in and getting the response, and then if you're disagreed, then you can go off to some other operation which the online platform has set up for resolving your dispute? I mean, Facebook or any of the others will have such a system.
Well, I'm going to come to the question of dispute and its relevance in a moment, but to answer my lady's question, there shouldn't be a distinction at all, because the work that is involved, so far as litigation services are concerned, which is what Section 58 is concerned with, it covers not only the work in responding to the response to the letter of claim, but also the preparation of the letter of claim. They are different pieces of work, but they are all it's all work designed to achieve the same outcome. And it's wrong to distinguish between the two, which is partly the problem with the Court of Appeal's approach in Lord Justice Dyson's decision in Gaynor. Well, yes.
Sorry. But we have to recognise this is a substantial expansion of litigation as generally understood, where solicitors' equitable lien has normally been raised in the context of proceedings in the courts. Now, except I wouldn't know, but I assume it also arises in arbitration. But what you're now talking about is how do we deal with the equitable lien in the context of new technology, where claims are made through online platforms?
Well,
and we've got to work out how this all applies, but it is an expansion of what we've understood the equitable lien to be, and we can't get away from that. That's the flip side of all this.
I'm not sure it's an expansion of the principle. I mean, it might be that there are more cases to which the principle could be applied, but I don't think it's an expansion of the principle. And modern technology, I mean, well, I'm going to deal with that, but with a great respect to the Court of Appeal, it's a curious judgment which seems to discourage, on one view, the expansion of litigation services into the more modified technological environment in which we're all now concerned. Artificial intelligence in bringing claims, whether it be small value, low value claims, or even larger claims, is absolutely with us and is going to increase. I mean, artificial intelligence is here to stay. And so I take my latest point, I'm sensitive to this point, that the principle to which we're seeking to rely here is being expanded and has been expanded by the court, I would submit already in Gavin Edmondson, to cases in which vast numbers of claims can be resolved through the use of technology. But that doesn't undermine the purpose of the purpose of the equitable lien, which is to recharge the solicitor with the fees that are that have been incurred in the pursuit and the instrumentality of the recovery.
One way of looking at it, Mr. Bacon, is that historically, at least I think up to now, only solicitors have had a lien. And maybe the way Lord Justice Lewison was looking at it is, well, if that's the position, what is it that solicitors are allowed to do but other people aren't? And on that approach, you look at conducting litigation, which is reserved to solicitors and a few other professions that are qualified for it, which has a pretty narrow definition of litigation services. If, on the other hand, the purpose of the lien is equally applicable really to anybody who's providing a service in claims recovery, then you take a more expansive approach to litigation services. But the corollary is, isn't it, that you can't, on that basis, reasonably distinguish between solicitors and other people who are allowed to do and provide exactly the same service.
Well, my lord, absolutely, and this is a point which is obviously floated in the Court of Appeal, and it's floated in the Supreme Court. But the issue, from my perspective, I act for a firm of solicitors who are regulated firm of solicitors, very respected firm of solicitors who are pursuing claims in that capacity. I understand my lord's intervention. It may be that in due course, this court or another court will have to consider the degree to which the principles that we seek to establish here, that the work in advising clients early on and bringing claims through letters of action attracts the equitable charge, the equitable right, the security. That may well be a matter for further debate by others in due course, but strictly it doesn't apply, Mike, in the context of this appeal. But I mean, that's not to duck the issue, my lord. I mean, I totally accept that it's something that's going to be of concern to my lord and my ladies. I entirely accept that. But query, the issue in this case is whether a particular amount of work falls within the current rubric of the charge. Does it fall within litigation services or does it not? That's the principal question with which we've been challenged by the Court of Appeal to answer.
But what I'm putting to is what you count as litigation services depends on an understanding of the principle. Is it limited to things that only solicitors can do in conducting litigation, which is a pretty narrow range of things, or does it extend to things that anybody can do, but which are part of a wider concept of claims handling?
Well, under Section 58, which is what we're concerned with, Section 58 only applies to Section 58 A, which is what we're concerned with. So ignoring at the moment the DBA amendments, they concerned legal representatives. So they concern solicitors, barristers, those who are regulated by the relevant regulatory authority. There is, as I said a moment ago, it's important we understand that Section 58 AA, which deals with DBAs, does bring into Section 58 claims management activities, but they too are regulated by the claims management or by a claims management regulator. Now it's actually the government, but still as a separate body. But to the extent that the court is concerned about the remit of Section 58, that is the limit. It's limited by the nature of the bodies entitled to enter into these sorts of agreements. and certainly from my perspective and my submissions, is that in the context of these sorts of proceedings, a no-win, no-fee arrangement, not a DBA arrangement, would apply to solicitors, barristers with direct access potentially, and claims management companies under Section 58A if they've entered into a damages-based agreement.
But this is not necessarily going to be in the consumer's interest, because there will be some bodies who will be able to efficiently make claims on behalf of the consumers who want to make them, and assist them in just the same way as solicitors, barristers who get an equitable lien, but they will have the problem of running a business without the equitable lien.
Wow.
So it will reduce the market of people able to provide these services.
No, I'm not sure that's correct. The market is likely to respond such that access to justice, to the contrary, is likely to be increased. I mean, the problem with the Ryanair business model, which we would submit, is deliberately designed to limit claims. It's to make life more difficult for consumers by requiring them to go online and fill in the forms and deal directly with Ryanair. The problem that the arguments underpinning their submissions is contrary to the principle of access to justice. We say that. Sorry.
No. Pardon me. I thought you'd finished.
We say that permitting and recognising that these claims can be pursued with the assistance of legal input, where the solicitor has an assurance that they don't have to chase thousands of their clients for their fees from the recoveries that have been paid direct to their clients, is going to provide access to justice. It's going to increase the ability of members of the public to have recourse for genuine claims. You see, the contest at one level, my lady, is do you end up in a world where you leave it for applying the context of lien, you leave it for the solicitor, the legal representative, to pursue their claim, for Ryanair to pay the damages to the client, and for the solicitor then to pursue the client for the fees that the client has agreed to pay. Not only agreed to pay, but they've agreed to the deduction to be made to the damages in the conditional fee agreement. So you end up with a world where you have a solicitor pursuing a claim against the airline or the Facebook, whatever it may be, with the prospect of having to then chase clients, claimants individually for payment. Or do you have a world in which the tortfeasor, the party responsible for the damages, pays the damages to the solicitor, to the legal representative, under which they then take a deduction? The latter has to be the more fairer, sensible and fortunate.
I was just going to say very briefly, I'm sure you can just correct me on this. If I went down to my local law centre, which happens to be a limited company, doesn't have a solicitor, and then assist me with my claim, will they be in the same position? It might be much cheaper for me to do that than to go to a solicitor.
They would, in a sense, they would be in the same position. They would be able to also be able to make the claim on behalf of my lady. They could
claim the equitable lien.
Well, that's the question which my Lord Legate poses, and on the face of it, it would seem pretty unsatisfactory that the law should make arbitrary distinctions between lawyers on the one hand and others and non-lawyers. I mean, for my part, I find the distinction difficult to grapple with, and the law probably does need to reflect the modern state in which we are all now engaged. As I say, for my purposes, as I understand it at least, I don't need to go that far, but I do see the force of the concerns that my Lord Legate has raised, and my Lady Arden. There would appear, Lady Rose, yes.
Well, yes, just rephrasing this problem, that You say we don't have to go that far, but obviously we do have to consider the implications of what we decide. And the worry is that if one doesn't limit it, as my Lord Legate says, to reserved services, then you are creating a distortion in the market between competing service providers, because those service providers who have the lien, they can sort out their fee basis on the understanding that they have a low level of unpaid fees, whereas those who, as you say, have to chase around the clients for the unpaid fees will have to charge more to cover their likelier higher level of bad debt. So there is a risk that if one makes an arbitrary distinction, which is not reflected in the kinds of services that are limited to solicitors, you are creating that kind of competitive distortion.
I accept that, but by limiting the application of the principle to reserved legal activities, which is not what the Court of Appeal has held, it's not what the Supreme Court held in Gavin Edmondson, would be inconsistent, in fact, with Gavin Edmondson. That itself would create an unfair distinction between those who are able to conduct reserved legal activities and those who can't, but who achieve the same outcome.
Mr. Bacon, correct me if I'm wrong, but I thought in Edmondson the court didn't limit the lien as a matter of principle to something that could be used by solicitors.
No, it didn't.
And took some care at the outset of its judgment to say that whether in fact it's limited to solicitors at all is simply not a matter which can be decided in this case.
That's exactly so, my lord, and that's how I effectively pursued my appeal this morning. I'm in the same position as Gavin Edmondson effectively was before my lord in that case. I quite understand that the court broadly will have an eye on where its decisions may go, but strictly it's not an issue for my appeal, because these are solicitors. There is no dispute that they're conducting work which they're entitled to conduct, that they do so under the regulation of the SRA and so on. But the question is simply on my appeal, whether the work that they were doing fell within the rubric of litigation services under Section 58. That's really what this case is about. And I'm going to come on to colouring grey in a moment, because I think it will help just to sort of set a broader scene. And maybe I can do that now in the course of the discussion. When Parliament introduced conditional fee agreements into the world in which we operate, thousands of claims were pursuant to conditional fee agreements up and down the land. In personal injury claims, 98% of them, I think, were the stats from April, settled without any need for proceedings at all. The claims are all pursuant to conditional fee agreements under Section 58 because legal aid was no longer available for these sorts of claims. The regime established the entitlement of a solicitor to charge a success fee on the work that was necessary to bring the claim. Success fees can only be recovered under Section 58. There's no other statutory route through which you can charge a success fee. Parliament was therefore saying that where solicitors undertake litigation services, they can charge a success fee. And for 20 odd years, no less, the law of this land has been that lawyers, solicitors, can charge success fees on all of the work they do from the moment they see the client, the moment they come in through the door, through the preparation of letters before action, the advice given before letter before action, right through to the end of the case. And the reason why colour is important is because in that case, the defendant insurance industry came along en masse. That you'll see from the Court of Appeal judgment. There was it was a huge case. Interested parties from pretty much every aspect of the practice of solicitors and barristers appeared. The insurance industry basically came along and said, we shouldn't be required to pay success fees in these straightforward cases until there's a dispute. Lady Arden's point. And this is why yesterday, while I was walking around my garden, I suddenly realised that in one sense, this point has already been looked at in a different context. And their case was, until you've got through initially their case was, until you've got through the protocols and come out of the other end, in other words, you're on the verge of issuing proceedings, there should be no entitlement to any success fees or any of the ATE policies that were then recoverable. And the very same question arose, really in the same context that Lady Arden has raised. Should the court limit the ability of solicitors to call on Section 58 and the no-win, no-fee arrangements that were prescribed by Parliament and the success fees and so on that followed, to claims only that were disputed claims, or should it expand it to all claims that of this kind? And the Court of Appeal, Lord Wolfe, then Master Rolls, held that it was important and critical for access to justice that clients should be permitted to enter into CFAs right at the outset of the retainer, and that they should be entitled to charge, the solicitor should charge a success fee on the work they are doing from that moment. Success fees are only chargeable on litigation services. Success fees have been charged and recovered, paid by clients, paid by the insurance industry on letters before action since that date, my lords and my lady. And so if we're in a world where Lord Justice Lewison is saying a letter before action is not litigation services, something very seriously has gone wrong. And not only that, the Rules Committee, I'm not going to give evidence, but I sat on the Rules Committee throughout this entire period of reform, as my Lord Biggs knows. The rules have been made to fix initially success fees when they were recoverable from the appellants, to cover this work, to cover the pre-issue, the pre-action work, including the letter of claim. And Parliament accepted, through the fixing of those success fees, that they could be charged on litigation services, including this work. Eventually, of course, such was the extent of the level of the claims, Parliament resolved more recently to abolish the recoverability of success fees, but nevertheless, solicitors can still charge them to the clients, and they are now fixed under the Section 58 of the regulations they're under. But you know, this idea that litigation services doesn't include the preparation of letter before action within the context of Section 58 is so wrong. It's utterly wrong. And I remember reading Gaynor, when it was first handed down, because Gaynor was the beginning of this, thinking it just is not right. And I'll come to it in a moment. But Gaynor was wrongly decided with respect to Lord Dyson, with respect to him. He was looking for a way to uphold the validity of the agreement, but he missed a big point, that around him, all about him, success fees, Parliament had sanctioned the charging of success fees on this sort of work. And so, you know, in one sense, as I just thought yesterday, I still think I'm right about this, that really, in one sense, is the end of my appeal. Because if I'm right about that, and this court wants to impose a limit to the extent to which the equitable principles can apply to litigation services, I say no more about it. We absolutely fall within the rubric of litigation services, the reasons I've given. The House of Lords upheld the Court of Appeal. So the House of Lords in Clarion Gray, there was a dissenting judgment of Lord Scott, but even he accepted that the vast majority of these claims were all going to settle. They were never going anywhere near a court. the court held and accepted that the Court of Appeal's approach of permitting success fees on all of the litigation services, which included the draft of letter for action, was justified. Now, my simple point is you can't have a world in which a letter for action for purposes of the charge is not a litigation services, the technical charge, but it is for other purposes. I mean, it's either litigation services or it's not under Section 58. Well, the other problem with Lord Justice Lewison's decision is that it means that clients have been charged this work under Section 58 unlawfully, because you can't. The law doesn't permit a CFA a contingent type arrangement unless it complies with Section 58. And if it's true the case that work done in advance of a dispute, as Lady Arden identified, until you know whether the dispute, if that work isn't litigation services, then there are literally hundreds of thousands of clients out there who've been charged success fees unlawfully. Which isn't right, of course. Plainly, drafting letters for action and advising clients at the outset of litigation is litigation services. Absolutely no doubt about that. And my lords, my ladies should be persuaded that that's the position. Yes, my lord.
Well, it doesn't do to just keep reiterating that it is litigation services. I mean, what matters is the principle that underlies it, and it can be litigation services for one purpose or another, but not for another. I think the centerpiece of your argument has to be, and I understand that it is, that it should match for the purpose of the lien what you're allowed to charge a CFA for, because the underlying rationale is the same.
Yes.
But if it isn't the same, then there's no anomaly in having a different definition for one purpose or for the other. So it won't get you anywhere just to keep saying, well, undoubtedly it's litigation services, because it all depends on what the underlying policy of the law is that we're looking at.
I totally accept that, my lord. But of course, the consistency here is critical, as my Lord Bridget said in Cabinet Everton. You know, that although it's an equitable remedy in a sense, having clear boundaries to which it applies is important, so that it can be applied, so to speak, on the nod. When you see it, it's there. And if one starts creating rules for what is the subject of litigation services, or whatever the correct boundary is for the charge, which is different to what solicitors themselves treat as that work, you do potentially end up in a world of inconsistencies and uncertainty, which is not desirable. But that's my answer to that. So if I could just go to Gaynor. Yes, my lord.
Before you move entirely away from Section 58, Section 58A4, I think, talks about it being any sort of proceedings for resolving dispute.
Yes.
Are you? I think you said you're going to come back to the question whether dispute resolution is at the heart. I simply raise it because I think I discovered when conducting the civil court structure review, probably the vast majority of claim forms actually issued in civil proceedings in the UK were not for resolving disputes, but just to get people to pay who, without disputing the debt, weren't paying.
Correct. Yes.
I'm really just asking whether you're content with the constraint that it is only about dispute resolution, which one might think you get from Section 58.
In my submission, this is also partly answered, my lord, by the Callary Gray approach to life under Section 58. Because, as I said, the defendants, they relied upon the word proceedings and the references to disputes. And their case was, until there's a dispute, you shouldn't be entitled to charge a success fee because of the definition of proceedings under Section 58. But the Court of Appeal said otherwise. So
in Callary
Gray, you can charge a success fee under a conditional fee agreement, even then there may not be a dispute at the time that you're undertaking the work, or at the time that you concluded the work. in one sense, the word disputes, resolving disputes, the word dispute isn't defined. Well, I accept that it could be read as Lady Arden has indicated, that until you know that the other side is defending something, is there really a dispute? But the way in which the law has proceeded under Section 58 is that is not the correct reading. It's a much more general, sort of generic phrase of resolving claims, resolving claims between parties.
Could you possibly make good that proposition in the orthodox way by perhaps showing us a passage in the case?
Yeah, so should we go to the colour in grey? I thought you're quite right, in fairness. We start with the Court of Appeal judgment, which you should find at page 2 of the supplemental bundle. As you can see from the head note, before getting into detail, these involve thousands of low-value claims where proceedings were not issued. They were all settled without the need to issue proceedings. And the question was whether the solicitors were entitled to recover the additional liabilities, the success fees, and the AT insurance premiums, which Parliament had permitted to be recovered under the Access to Justice Act. And the success fees are obviously only chargeable under Section 58, as I've already indicated. And the question was whether or not it was reasonable for clients to enter into these sorts of arrangements before there was any dispute, effectively, so as to enable them to recover the success fee, because the success fees were, as you would imagine, designed to compensate for risk. And it was said by the defendants, until you know there's a dispute, you don't know whether there's any risk or not. That was the centre of the plank of their argument. And one sees it. Paragraph 10, heading 10, paragraph 80 of the judgment, page 20. There's a heading called the prematurity issue. There were different issues, but the prematurity issue is the issue with which this court is concerned, and that basically describes the situation that I've just outlined. Was it premature for clients to instruct solicitors or solicitors to encourage clients to enter into CFAs before there was a clear dispute between the parties? Because what was going on was solicitors were entering into these arrangements straight away. And the paragraph 84, we're concerned with such a category of claims for the consequence of motor accidents on the claimant's account of the accident. The solicitor reasonably concludes that the claim has every prospect of an early settlement as to both liability and quantum. At that stage, the risk assessment results in the termination of the uplift is likely to turn not on the particular features of the instant case, because there are none. You see that? So that the courts are recognising that there's currently no idea about the risks of the case, because it's only just started and you don't know what the other side's response is. And so they were effectively setting success fees by reference to their experience in other cases. The paragraph 86, the vital issue in relation to uplift that is raised on these appeals is whether the court should allow recovery of uplift, whether this is agreed at the initial stage on the basis described above, or whether it should require all solicitors to defer agreeing uplift until the defendant's response to the claim is known, so that the risk of failure can be assessed on an individual basis. The latter approach would result in a high uplift being justified in a minority of cases, but a small, if any, uplift in the majority, where those acting for defendants will make it plain that liability will not be contested. And at paragraph 87, it's the defendant's arguments that the cost of taking out ATE and of the uplifts and so on is excessive. And it should only be recoverable where there's sufficient information is available to form a reasonable prognosis. What would be the risk involved in a claim? And the defendant has further argued that the claimant cannot reasonably incur these liabilities until the reaction of the defendant to a claim is known and the merits of any defence raised considered. At that point, so the defendants argue, it will be apparent whether there is a risk that the claim may fail, which makes it reasonable to enter into a CFA at that point. And you can see from paragraph 89, very similar percentages are given in relation to the Ryanair cases. Over 90% of cases are expected to settle and may settle in the protocol period. The solicitors at paragraph 90 were contending that it's reasonable to enter into the CFA right at the outset to pursue the claim, giving instructions to the solicitor not to expose himself to liability costs for the two of the reasons. And obviously the solicitor will be anxious to offer claimant services on terms. Whatever the outcome, he will not find himself liable for costs, which is equally applicable here. And at paragraph 91, the Court of Appeal held that from the viewpoint of both the claimant and his solicitor, it will normally be reasonable for the CFA to be concluded and 80 taken out first when they first instruct the solicitor. And the paragraph 92, they considered the issue in the light of the purposes of the new regime, which is to facilitate access to justice on the part of those who cannot afford the costs of litigation. And the court at 93 dealt with and addressed the effect of the decision of including success fees as recoverable costs from the defendants from the outset. And at paragraph 99, there are the conclusions. Page 23. Sorry, 98. Is it 98? 98 is right. Yeah, 98. The defendant, there we go. 98. The defendants contend, however, that it is unjust to saddle defendants with the cost of 80 insurance premiums and success fees without giving them a fair chance to identify those cases where liability in quantum is not disputed, so that success is assured. It might be said in the same context, my Lord Legate and my Lady Arden, you know, the defendants would contend it's unjust that, not sure on what basis the defendants here, Ryanair could contend it's unjust that the actual charge should only apply in a case where they themselves have identified the dispute, because it doesn't cost Ryanair any more money to settle the claim. But be that as it may, the Court of Appeal saw the force of the submission, but concluded that at least in the circumstances of the two appeals that were then engaged, and we know from history as it's passed that this applies throughout the civil litigation arena hereafter. There was some nervousness on the part of the Court of Appeal back then, but this stood the test of time. That if the new regime was to achieve its objective, legal costs of claimants whose claims fail should fall to be borne by unsuccessful defendants in the manner described above. On these appeals, the court has to decide whether to permit liability for success fees to be apportioned. If the latter alternative is adopted, the defendants who contest liability will not share liability for costs in a manner which is equitable. Level 4, claimants naturally want to know at the outset that a satisfactory arrangement to cover the cost of litigation has been made, which provides sufficient protection for them no matter what the outcome. That's relevant here. And claimants who incur liability for costs their legal advisors as soon as they give instructions. Once the defendant starts to incur costs in complying with the protocol, solicitors and claim grounders are anxious to be able to offer legal services on terms that claimants will not be required. Now, of course, those principles apply equally here. And it followed this whole rationale of thinking, my lords, that solicitors could charge clients success fees on this early work, even before there's a dispute, and recover the success fee. So it was treated, as I say, without falling into the trap, my Lord Legate, simply repeating the same point. But it goes to show that even where there is no dispute, Section 58, as interpreted by the Court of Appeal and the House of Lords thereafter, covers the pre-litigation work with which we're here concerned. And I would submit it would be curious if the extra charge sort of had a dividing line between categories of work which could be described as sort of dispute work, taking on Lady Arden's point, that only work from a certain temporal moment in the case could be subject to the charge, but vitally, equally significantly vital work prior to that temporal moment wouldn't be subject to the charge. That would, on the face of it, be an unprincipled approach to the question of the charge. Why should the solicitor be deprived of the charge? Simply by a temporal moment in time that delineates between a state of affairs then known to solicitor, where the work is equally instrumental in the recovery. And that's what the charge is about. It's never been about timing. It's always been about, has the work undertaken by the solicitor been instrumental to a significant extent to the recovery? My lady, yes.
Well, isn't that whole concept of instrumentality, though, tied up with the question of whether there's a dispute? Because if the defendant would have paid anyway, if asked, how is the solicitor's work instrumental in obtaining the compensation?
Well, my lady, the answer to that respect it's a question which could be asked in the Gavin Edwards context too. Is that, of course, the solicitors were instrumental because they were asked by their client to pursue the claim. They advised on the claim, they put together the letter of claim setting out the basis on which the claim is being made, and submitted it to Ryanair for payment. That clearly was instrumental. It was the principal reason for Ryanair paying out in that particular case. I mean, the same could be said in Gavin Edwards and the Supreme Court's analysis of those cases. But we don't know that the defendant would have paid out without recourse to solicitors. We know that they would have done, because in those very cases, the defendants captured the claimants or tried to capture the claimants and pay out and offer them payments before the lawyers got involved. It's not as though Ryanair do that. I mean, that's the slightly absurd thing about this. Mr. Kennelly's clients are seeking to say, well, we would have always paid out, but they don't offer. Get off your plane at 3 o'clock in the morning, having been delayed 6 hours. They don't say, here's a check, as they did in the Gavin Edwards. Do you know what I mean? You have to make the claim. And whether you do it yourself or through a solicitor, you're instrumental in the recovery if they then pay it. Part of the argument in Gavin Edwards was the opposite, my lady, was that Haven were always going to pay out because the facts demonstrated that. Haven, as I say, tried to capture claimants at the accident or within hours of the accident by saying, here's 450 quid or here's £2,000. So they were saying, that's what their case was. Well, there's been no instrumentality here at all, because we would always agree to pay it. And Lord Briggs, with respect, said no. Of course, the solicitors are instrumental in recovering it. They have actually they put in a claim in accordance with an established protocol, and their work was to a significant extent instrumental in the recovery. My case is stronger because, as I say, you don't have the opening gambit from Ryanair to say, we shall pay. If they did that, there wouldn't be a problem, but they don't. That's the problem. And my lady, yes.
Can I just ask a point of detail? Does the entitlement under the Europe-wide payment for delay scheme depend upon it being claimed, or is it an entitlement that arises purely from the delay? If you don't know the immediate answer,
I don't know the immediate answer to that, but certainly the cases proceed on the basis that it depends on a claim, and I'm sure that Mr. Kennelly will accept that, because, as I say, it's certainly the contractual provisions, the Ryanair contractual terms require a claim to be made. As you know, they they now say that the claim has to be made first by the passenger direct. It's not as though they're saying in their contractual terms, you know, whatever happens, we will pay. So it seems that they work on that basis too, my lord.
The reason I ask is this, just so you know, the principal basis, I think, on which the Edmondson case proceeds is that the solicitor's work makes a significant, or whatever you want to call it, contribution to the coming into existence of the shows in action on which the charge bites. And in a case where the airline just pays up in full, without there being a prior judgment or arbitration award or settlement agreement, it just gives rise to a question in my mind, well, what is the shows of action against which they're paying? Is it an original debt under the delay scheme, or is it a new shows in action that results from the claim having been made against them?
In my submission, it's the latter, my lord. It's a claim having been made that they agree to then either dispute or honour. And I think that must be right, because there are, of course, defences to the claim. Two of the authorities that have been put in yesterday by my learned friend demonstrate the extent of those defences. I mean, my learned friend put those authorities in, I think, to show that the majority of the cases dealt within the small claims track, as indeed they are. But any reading of those two authorities, at least as I did yesterday, demonstrates to me the broad, actually quite complex nature of some of the defences that can be deployed in these cases. Suggests that it's not an absolute entitlement simply because there's been a delay, they shall pay. One has to interrogate the nature of the delay claim in order to resolve the claim itself. And so it's no different to any other claim in that sense. And I hope that answers that question. My lord, I'm going to go to Gainer quickly, if I may. It's at tab 17, because there are two problems with Gainer, which I think it's important for me to highlight in this context, seeing as my lords are considering these issues. I'm conscious of the time. It's 11:41. 11:45 is the.
Yes. Well, if you're about to move to Gainer, it might be a good moment.
Thank you.
We'll adjourn then for 5 minutes until about 13 minutes to. Yes, Mr. Bacon, please continue.
Thank you, Lord. I was going to take my lord and my ladies to Gainer, which is at page 832 of the bundle, which is where I say this all started to go, unfortunately, wrong in terms of what litigation services under the Act in Section 58 covered. Page 832. The retainer letter, just very quickly at page 835, paragraph letter E. If your claim is disputed by your opponent and you decide not to pursue your claim, we will not make a charge for the work we have done to date. So there was effectively a conditional, or I was arguing there was a conditional aspect to the solicitor's entitlement to be paid. If the claim is disputed and you decide not to pursue it, then we will not make a charge. And the question was whether that term rendered the agreement, the whole of the agreement, unenforceable, because it wasn't a compliant conditional fee agreement under Section 58. And Section 58(1), as my lords will know, says in terms that if a conditional fee agreement doesn't satisfy the terms of Section 58, it shall be unenforceable. And that was because, we'll look at it in a moment, but that was because this was Parliament's only intervention in a common law regime where Champerty maintenance had been outlawed for centuries before. I think as Mr. Ian Burnett, QC as he then was, in the Hollins case, described Section 58 as creating an island of enforceability in a sea of unenforceability. And this is actually what it does. And so Lord Justice Dyson, as he then was effectively looking for a way in which to uphold the enforceability of this retainer, and did so, but perhaps cleverly at one level, by deciding that the work that was undertaken in respect of the aspect of that part of the case, namely the drafting a letter of a claim advising the claimant on the dispute, the potential dispute, was not litigation services. And one sees that from paragraph 16 and 17 of the judgment. 16, in my judgment, the last paragraph on the third page is an offer to waive fees for modest pre-litigation services. Could such services be litigation services within the Act? More particularly, could such services be services which would be reasonable to expect a person contemplating exercising under section 119? It's a question of construction. It does not depend on whether the claimant decided not to pursue the claim. Approaching as a matter of construction, which is paragraph 17, I would hold that the work done before a decision is made not to pursue the claim pursuant to the last paragraph on the page is not the provision of litigation services. In my judgment, contemplated proceedings are proceedings of which it can be said that there is at least a real likelihood that they will be issued. And this is my Lady Arden's point. Until the potential defendant disputes the claim, it is not possible to say that the proceedings are contemplated. Advising a client as to whether he or she has a good prima facie case and writing a letter of claim are not enough to amount to litigation services. But as I've said, Callery wasn't brought to the attention of the court in Gaynor. None of the points I made about the fact that at this time, so in 2006, the law was permitting freely success fees to be charged on this work on the premise that it was litigation services. And the decision was just plain wrong as a consequence, I'm afraid. The House of Lords found the Court of Appeal on this point. But there's another fundamental problem with the judgment, which is just an aside, but it's important because the court is looking at the judgment. It's obviously an important judgment from Lord Justice Dyson, who plainly deserves respect. But what happened was that because he decided that it wasn't a conditional fee agreement, it was nevertheless still a conditional fee agreement in the sense that liability for the fees was conditional on something happening. And he inadvertently, as I see it, created a third species of conditional fee agreement. You see that in paragraph 19. He said, it's clear that the retainer letter has been drafted with care. As Mr. Foy points out, it increases access to justice, so it's a sort of new type of agreement. It enables a potential claimant to obtain legal advice and take a few steps towards litigation in order to see whether the defendant would admit liability at an early stage without exposure to a serious risk of cost. It is of benefit to claimants to enter into such agreements. The defendant benefits as well as it would avoid the potential liability to pay a success fee. It would be unfortunate if such retainers, calls them such retainers, were to be unenforceable. Well, if they're not compliant with, if it's not covered by Section 58, then what is it? I mean, the law is very clear. A solicitor cannot enter into any form of engagement which provides for a conditional payment unless it is non-contentious business under which the Section 57 applies, or it falls within Section 58. This work is not non-contentious business.
Isn't it saying that this is non-contentious business until it becomes contentious because it's disputed? But I thought your case was that there should be an equitable lien even for uncontentious business, or are you not?
Yes. So the reference to contentious business in the Court of Appeal's judgment below is a real concern because, as my lady has identified, contentious business and non-contentious business are they one morphs into the other. You can have work which is undertaken without any court proceedings, which is non-contentious, but that same work in fact becomes contentious proceedings when proceedings are issued. And in Gaynor, proceedings were issued. So on a strict analysis of the position, the work undertaken pre-litigation that Lord Dyson was looking at was contentious because the proceedings were ultimately issued in the case. It's just another reason why the decision is with respect wrong. I mean, it couldn't be non-contentious on the facts. It wasn't Section 58 because of the Lord Justice Dyson's decision. So that's why I asked the question, well, what was it then? It was a third species of a conditional figure in which the law doesn't recognise, I'm afraid. So Gaynor your Lordship should hold that Gaynor is wrongly decided, but it provides obviously the plank for Lord Justice Lewison to arrive at the conclusion he arrived at. Can I just take you quickly to Hollins and Russell? I'm not going to stay long on it. Yes.
Just before you do, Mr. Bacon, you said this was contrary to binding House of Lords authority. Did you show us Callery and Gray in the Court of Appeal or the House of Lords?
I showed you the Court of Appeal. The House of Lords. You're quite right, my lord. The House of Lords decision is in that supplemental bundle. Is at page 32. And what the House of Lords effectively said and held in that case was that primarily they said that these are matters which the Court of Appeal is far more equipped to deal with than us. They certainly identified with the defendant's concerns, and Lord Scott and Lord Hoffman shared some of those concerns about the risk of success fees, sort of overtaking the world, so to speak. But they left it ultimately for the Court of Appeal and upheld the judgments of the Court of Appeal. And ever since, as I say, my lord, the rules, the practice of insurers, the practice of claimants lawyers has been that litigation services includes writing letters for action in this world. I mean, it is just as simple as that. Insurers pay success fees when they're recoverable on that work. And Gaynor is just wrong. And it's a hair running, I'm afraid, which has infiltrated itself, found itself into the court below. And for reasons I've given, provides the plank for which I seek this court's indulgence. I was going to take you quickly, if I may, and I will be quick about it, because Hollins and Russell is about CFAs and enforceability. It's not about charges and liens. But in terms of your reading in due course, can I just commend to the court Lord Justice Brooks' judgment? Lady Arden might remember the case, she might not, but certainly it's a seminal case on conditional fee agreements and their purpose. When in 2003 the court came to look at them really for the first time in terms of enforceability. And again, Lord Justice Brooks was so good at was orchestrating an appeal where lots of interested parties had their say, and it stood fully the test of time. And I commend to the court paragraph 9 in terms of the history of the legislation.
Have you given us the reference for it? I'm not sure you have.
So on page 889 is the reference. Lord, this case starts at 878. I'm sorry, my lord. 878 is where you'll find the decision. The paragraphs which I'm recommending to my lords and my ladies is at page 889, paragraph 9, right through to paragraph 14 in terms of the history of what it is permitted that solicitors can and can't do. And then paragraph 34 of the judgment, which just reminds us all that in those days there was a whole series of regulations called the conditional fee agreement regulations, which governed the enforceability of these agreements. And I just point out that those regulations required the solicitors right at the outset to give pre-contractual information about steps that are going to be taken in the claim and about other ways of funding the claim. And the idea that that wouldn't include discussions about letters before actions and so on is just frankly unthinkable. And then paragraphs 37, sorry, paragraphs, so 37 through to paragraph 40 about the contemporary concerns that were raised about CFAs. The point I wanted to make here at paragraph 39 about technology, just beginning to infiltrate the personal injury market here. The views expressed by a solicitor in giving evidence in the case, developing scene are best reflected on the evidence given by Mr. McCulloch, head of personal injury department. He described how the high levels of client care and service demanded in the 1990s by both legal expenditures and legal aid board demanded a level of investment in IT systems which could only be supported by an increase in the volume of work undertaken by the firm. The demise of legal aid and the arrival of new ways of doing business facilitated Part 2 of the 1990 Act, persuaded him there's a pressing need to be able to process cases in large numbers without diluting quality. And he was of the view that this profession would have to look at innovative ways of providing national regional service without losing the essential qualities previously offered to clients on the basis of bespoke local service. His hope was that in this way access to justice would be maintained and a higher quality of service would emerge and reduce the number of hopeless claims. And that's precisely what goes on in the world in which we're concerned with today. I'll come back to that in a moment. And I query whether the lien and whether its principles underpinning it should be any less relevant, simply because the lawyers have promoted access to justice in innovative ways, which back in the 19th century and early 20th century, the Court of Appeal, in cases like McGodiction, weren't obviously facing. And then at paragraph 39, paragraph got a wrong reference there to contentious business agreement. You just don't listen about what it is. It's the passage of contentious business agreement. There's a passage, my lord, which I've got a note for paragraph 39, but it's the incorrect reference. Maybe that where the Court of Appeal in Callery held that the conditional fee agreement under Section 58 was a contentious business agreement. This is quite important for your considerations. And I will come back to that in a moment. I'm going to ask my junior just to find the reference. And then at paragraph 191, finally, for reading, is a question about delegation. It's paragraph 93, I've just found it. Paragraph 93, page 910. Paragraph 93, page 910. In any event, as we've already said, again, a great deal of argument before us was directed at qualifying the application of that principle in these cases. Ultimately, however, it became clear that the CFA is a contentious business agreement to which Section 63 of the Solicitors Act applies. And if the solicitor cannot enforce the agreement against his client, then the amounts provided for in the agreement are not payable by the client at all. This was all in the context of whether the conditions required by the section and by the regulations had to be met and what the effect of the failure to do so was. But I just raised that passage of 93 that following the arguments, the courts proceeded on the basis, and they have hitherto, that a CFA is a contentious business agreement. And of course, in answer to my Lady Rose's point, that's in circumstances where in these very cases in Holland, they're cases again which settle without the need for proceedings. And so you're entering into an agreement which is called a contentious business agreement in respect of business which initially you might consider to be non-contentious. But they're defined to be contentious business proceedings in the event that proceedings might well be issued, thus converting the work into contentious business. It's a very odd world. I mean, one of my future ambitions is to, I mean, the Act, the 1974 Act is outdated and needs serious reform. There's no question about that. This whole business of non-contentious business and contentious business will need to be looked at in due course. But for what it is today, that is the position. And I was going to just refer finally in that case to paragraph 191 about delegation. because points are made in the evidence about the fact that Bott and Co have, 2 or 3 solicitors here and there. The rest of it is paralegals, and the rest of it is computers. At paragraph 191, Mr. Burnett was submitted that Parliament's anxiety to protect consumers was amply demonstrated by the serious sanction which it imposed for non-compliance with the regulations. The court accepted that the fact that work is delegated through lawyers to junior unqualified staff matters not, provided that there is at the end of the day a solicitor at the end of the tail, so to speak, overseeing and regulating the work that's being undertaken. And so none of the points that Ryanair takes against us in terms of the qualified or unqualified nature of the work bears proper scrutiny. So I now turn, if I may, having digressed slightly, to the 3 points that I referred to right at the beginning of my submissions that Lord Justice Lewison referred to in paragraph 58 in the court below, which led him to the conclusion that the work that Bott & Co was doing was not, quote, litigation services. And the first was that the nature of the work was mechanical and formulaic, to use his language. Now, we submit it's unclear why the simplicity or the success rate of Bott's cases is relevant to whether or not the work carried out constitutes litigation services, or indeed why it should not attract the benefit of the extra right. I repeat the Supreme Court's judgment and decision in Gavin Edmondson. So long as the work, however simple, was instrumental to a significant extent to the recovery, that is enough for the charge for the right to apply. And indeed, none of the authorities, in any of the authorities going back to the 19th and early 20th centuries to which we've been referred, none of them seek to draw lines of distinction by reference to complexity or simplicity of the work. Furthermore, the use of the word mechanical is not understood. I mean, if insofar it's intended to refer to the use of technology, which I dare say it is, it shouldn't have been relied upon by the Court of Appeal as a relevant factor. We have come a long way in the last decade, indeed the last 5 or 6 years, so far as the use of technology is concerned. It's certainly a long way since 1917, where in Mogadishu the court was considering the application of the equitable charge. Why should the equitable charge be displaced? Simply because the solicitor applies his legal skill through the operation of the artificial intelligence that he incepts to bring about the recoveries that are achieved. They are still exertions on the solicitor's part, and the evidence in the case shows that the legal expertise within Bott & Co was used to develop the systems that are now in place. And you can't say that, oh, well, because it's become mechanical, these are no longer claims involving lawyers. I mean, it's just plain wrong. The solicitor in Gavin Edmondson, they used AI. They all do. The portal itself is a computer-based system. You have to log on online. Personal injury litigation and litigation of this type, these debt claims, straightforward debt claims, are not pursued by going to a solicitor in the high street and saying, I have a debt claim. They are dealt with online through systems of the kind of which are in place here. And when we submit that a solicitor who uses AI, we should not be treated any differently from the rather more sedentary solicitor, perhaps in the home counties, who uses a typewriter and a secretary. Both are entitled to the equitable charge. Both are instrumental in the recovery of the damages that are secured. They're instrumental in different ways.
I can't remember the timing, Mr. Bacon, but was the RTI portal one of the things being developed and possibly thought about by Lord Justice Brooks in 2003 when he talked about promoting access to justice by the use of innovative IT?
No, so the portals came in later. Yeah. You had Lord Justice Brooks effectively upholding the use of conditional fee agreements and so on for access to justice. At that time, you had recoverable success fees, which then became fixed through fixed success fee rules. And then it became obvious that because the courts were being clogged up with these claims, that it was necessary to devise a system to resolve them outside of the courts. And so that's when the portals began to be developed, which was later on. Pretty fast moving, really, in the context of litigation across the centuries. In the last 10 or 15 years, there's been huge developments in the orchestration of these sorts of claims, both procedurally and mechanically.
As far as I can recall, the Portal Co is solicitor-led and managed, isn't it?
It is indeed, yes. Yes, it is. On both sides, there are defendant representatives and there are claimant representatives that are involved in the management of the scheme.
Thank you.
And I might add, my Lord Briggs may know, and indeed my lords and ladies will also know, and forgive me if you do, and I accuse you of not knowing, but certainly at the end of this month, there's going to be another significant change brought about by the whiplash reforms that they've been colloquially called. The Civil Liability Act of 2019 comes to force on the 31st of May of this year. And my lord, the court will know that there are going to be fixed tariffs for whiplash claims. You know, that if you've got a whiplash claim which didn't last any more than 3 months, you get £240.
Yeah.
If you've got one that's more than 12 months but less than 15, you get £2,040. You know, there's a tariff that's going to be applied, and this I think, if I may say so, sort of dispels one of the other criticisms that Mr. Kennelly's client seeks to deploy, and it's one of the points that Lord Justice Lewison, I'm afraid, deployed against us. That he says that, well, there's no. It's the second point. There's no evaluation of quantum. But I mean, the same will apply, you know, on the 1st of June of this year, in respect of accidents occurring thereafter. But it can't be said, surely, that the equitable right that arises as a consequence of the exertions of the solicitor should be no less prominent in the ability to recover the fees and charges that have been incurred. This is where the world is heading. You know, litigation of this kind is heading its direction towards platform-based resolution. And the law, in my submission, equity in particular, shouldn't be concerned necessarily with the ease by which the recoveries may be made. It's the principle underpinning it is, have the solicitors, has there been legal input which has resulted in the recovery, which underpins the principle. And that should be the focus. The focus shouldn't be on the level and extent of the quality of the work undertaken by the solicitor, because you then immerse yourself in all sorts of factual, quite difficult, potentially factual arguments, which unravel the edges of what ought to be a firmly established principle in our submission. The use of technology reduces costs. The use of technology makes access to justice easier to most of us. I mean, a general consumer who's required by Ryanair to fill in all the forms might well say, well, why don't I get my lawyer to do that? Why don't I get Bott & Co to do that for me? More than happy for somebody else to fill in the forms and take on the running. I haven't got the time to do it. I don't want to do it. It's providing a proper, valid service to consumers deserving of compensation. And I really do say that it's quite unfair for the Court of Appeal. I mean, my sense of the Court of Appeal's judgment is, and indeed the court below, was that this was seen as a sort of not dirty business, but it's a sort of, there's something about the approach taken by the courts here, which doesn't properly reflect the genuine nature of these claims, in terms of they are genuine claims for compensation for sometimes terrible disruption. My lady, yes.
The difference, one of the differences between this scheme and the RTA scheme is that there doesn't seem to be any mechanism where Ryanair is liable to pay the costs, and so the costs all come out of the compensation. Now, that seems to me a difference between this whiplash claims that you're talking about and the RTA, where the fixed costs are payable by the putative defendant in addition to the compensation. Now, that's not the case with this system, as I understand it. So what difference does that make? What does that tell us about whether this is a dispute of the same kind as those other?
Well, my lady is right to make the factual distinction, but in fact, on proper analysis, it's a point weighing strongly in favour of the charge being applied in these cases, because Ryanair knows that the solicitor's only entitlement to be paid is out of the damages, and so by withholding by sending the damages to a third party to the client direct, it knows that the solicitor isn't going to get recompensed by Ryanair through some other additional mechanism. So it's a stronger reason for equity to stand in to say, no, Ryanair, you should pay the compensation direct to the solicitor. I mean, this is a point of strength in my submission. My lady is right to say that under the portals, there are fixed costs payable in addition to the damages. And it might well have been the insurance case argument in that case that, well, you know, the actual principle shouldn't apply here because there is a right to payment directly from us under the portals outside of the remedy of the damages. Do you follow? But here, the strength of the argument from my perspective is that the client agrees, we'll come to the agreement later, but the client agrees that the fee should be deducted from the damages. Ryanair knows that the solicitor's only right to payment is from the damages. Ryanair knows that there's no other entitlement to costs under a portal like the kind that my lady, Lord Lady Rose has referred to, but nevertheless requires, forces the damages payment to be paid to somebody other than the lawyer. This is absolutely a case where equity should step in to say.
Well, Mr. Baker, I'm noting that we're up against your time allowance.
Yes.
It's fair to say you have been subjected to a great deal of what some might call injury time. But nonetheless, time limits are time limits.
They are indeed.
We have to give time to listen to your opponent. So I can give you a minute or so just to round up. We are, I'm afraid, going to have to listen to your opponent very shortly.
My lord, to be honest, you have my submissions in extensive written arguments. I mean, I hope that I know I've run out of time, but I hope I've answered my lords and ladies' questions sufficiently. I'll obviously have a short right to reply, and at this point, I'll hand over to Mr. Kennedy, who probably has sufficient time to deal with the submissions.
Yes, thank you, Mr. Bacon. Mr. Kennedy.
My lords, my ladies, I will address you first on the question of principle, the proper scope of the equitable lien in relation to solicitors, which I hope will cover the first, second and fifth grounds of appeal. Then I'll turn to whether the Court of Appeal erred in finding that the particular services provided by Bott in this case were not litigation services or contentious business. That's the third ground of appeal. And then there's the question of whether there is a discretion to exercise, and that's Bott's fourth ground. Of course, if you're against me on those grounds, there is still the question of whether Bott has in fact a contractual entitlement to its fees, or whether its CFA is enforceable. But it's common ground that that question would need to be remitted. And you see that from Bott's case at paragraph 85. So turning then to the question of principle, we say that this court in Gavin Edmondson intended the scope of the equitable lien to be determined by its purpose, namely access to justice. Access to justice presupposes a dispute. If there is no dispute, the claimant does not need access to justice. And because of the importance of access to justice, solicitors are granted this powerful protection. It is unique to them and gives them priority, for example, in any insolvency, as we shall see. It gives them a privileged status denied to other professionals who also assist in providing access to justice. And there is, we say, no policy basis for extending the scope of the equitable lien to other work that does not involve access to justice. In undertaking conveyancing or transactional business, for example, there is no policy reason for solicitors to be placed in a better position than other professional advisors. We say the law certainly does not say so. Such an extension, even if it were justified, would be a matter for Parliament. Forgive me, Lord Legate.
If the purpose is, as you say, access to justice, then it isn't actually tenable, is it, to restrict the lien to solicitors? Others who perform a similar, wherever the boundary comes, but these days, solicitors don't have a special privilege anymore in providing access to justice, and where others can do the same, it must, in principle, apply to them, the lien. That's the logic of the rationale, isn't it?
Potentially, yes, my lord, and no doubt that's why Lord Briggs made that qualification at the beginning of Gavin Edmondson. And one can see powerful policy reasons for that extension. In the same way as in the Prudential case, which I should take you to briefly, the Supreme Court saw powerful policy reasons for extending legal advice privilege to professionals other than lawyers. But as in Prudential, we would counsel caution. Such a large extension of the equitable lien to professionals other or to businesses other than solicitors is properly a matter for Parliament, and, if I may add, isn't raised squarely in this appeal. It's not Mr. Bacon's case, although he touched on it briefly, that this court in this judgment should extend the equitable lien to professionals and businesses other than solicitors.
But it's part of the court's function to try and find a principle that underpins a power or the exercise of it, and we must try and identify the principle, mustn't we? And if that means that it could be applied in another case to somebody other than a solicitor, well, so be it. That's how the common law works.
But again, if I may invoke Lord Briggs in Gavin Edmondson, and I'll take you to this passage. Equitable is flexible and the common law evolves. Equity is flexible and the common law evolves, but it must do so by reference to the established principles. And we say, pursuant to those principles, and bearing in mind that access to justice is the underlying purpose of the equitable lien, it should be given the more limited scope for which we contend, confined to solicitors. One could imagine in a particular case it being extended to barristers potentially, but the consequences of extending it beyond solicitors produce consequences which are beyond the scope of this appeal.
Well, on one view, it's not an extension of the principle at all. It's just that the world has changed. The world used to be that the only regulated people who could pursue claims were solicitors, but that's all changed now. The principle may be the same, but the world has moved.
I mean,
Well,
in fact, Bott & Co is not a solicitor. I think it's a limited company, presumably run by solicitors and regulated by the Solicitors Regulation Authority. In fact, it's a limited company and not a solicitor. Is that not right?
Mr. Bacon is better placed than I am to answer that question. But
I'll leave it to reply. It's called limited.
The point that was fairly made, I think, my Lady Rose was, and Lady Arden, was that in that respect, Bott is competing with businesses that have no solicitors in them at all, claims handling firms. It's competing in that market. And if this court is minded to extend the equitable lien to all, if you want to assume access to justice in the broad sense that Mr. Bacon outlined, and it does in this case, where does one draw the line? The safe and principled thing to do is for the court to maintain the position in the law, which is that the lien is restricted to solicitors. And if there is a policy reason for extending it, that's a matter for Parliament, because the consequences of the lien are so profound. It is an extraordinarily powerful equitable intervention and can create real change. Well, it would have real commercial effects in insolvency in particular, if it were to be extended to all those even tangentially involved in facilitating access to justice. Forgive me, Lord Legate.
Well, on one view, Parliament's already made the decision for us. It's decided who, and it does decide from time to time, who shall be regulated and entitled to pursue claims under, for example, conditional fee arrangements. That Parliament has made that decision. And if it's made the decision that other people shall have those rights to conduct litigation in that sense, then we would be remiss not to make the lien conform to it.
Well, again, I'll come to this when I, as you said, in the orthodox way, take you to the authorities which actually make good the assertions which I'm making. But where Parliament has intervened directly on the question of the actual lien, it has done so in the Solicitors Act 1974, which mirrored the common law at that time, which was that the lien applied to proceedings. And that's what you ask for, a direct intervention in this area by Parliament. That's it. Now, one can draw analogies from the application of CFAs, but those are analogies and not perfect analogies at all. And where Parliament has intervened in this area, it has restricted the lien to proceedings in the traditional sense. Now, we accept that Gavin Edmondson has stretched that beyond court or arbitration proceedings to other forms of proceedings, including ADR, and we'll come to that. But that is a principled and relatively narrow extension beyond the preceding position that we saw in Mereditch in the Court of Appeal. And that is sufficient for the purposes. That is sufficient to do justice and provide access to justice. Beyond that, it's a matter for market forces and Parliament, we say. And this court should be slow to wade into that area where there are many competing interests not represented before you today. Lord Burrows, sorry.
Yes, I think you have just said in your opening submission that you are equating access to justice with dispute.
Yeah.
Yes.
And I'm just wondering why you say that. You might say, mightn't you, that legal claims that access to justice is based on there being legal claims brought. And one might look at this scheme that Bott was setting up its business model and say, well, as a result of that, many clients got access to justice. That is, they had their legal claims satisfied. So why are you narrowing the scope of access to justice to disputes?
So there are two answers, Lord Burrows, to that. And again, I'll come to it in the authorities when I come to them. And forgive me if I'm not taking you to the authorities. I will take them, but I'm going to take them when I come in the order of my submissions. But just dealing with it briefly. The constitutional principle of access to justice has traditionally been understood to involve access to courts or tribunals. And I can take you to that principle. It obviously, in the modern world, is understood to extend beyond that, as it was in Gavin Edmondson, to other forms of dispute resolution, ADR and so forth. But all of them involve a dispute. And they involve a dispute because it's only where there is a dispute that the subject requires access to dispute resolution, to justice.
Okay.
Now,
can I test that? Please finish first. I want to test it by an example.
But if I may just finish then. The point here is that in this particular example, one mustn't lose sight of the fact that one is applying the equitable lien to a particular set of facts, which is the Bott model. The evidence does not show that the Bott approach is necessary to provide access to justice. On the contrary, because of the nature of the scheme and the nature of the legal right under Regulation 261/2004, a passenger can secure justice, if that's how Lord Burrows characterises the payment, much more straightforwardly and easily by accessing the airline directly. The evidence, the unchallenged evidence, is that it's a more straightforward process simply to fill in the form provided by the airline. And that involves less work, more money, and less time than the Bott model. And so in these particular circumstances, as the Court of Appeal held, this particular process was not akin to the RTA protocol and did not involve access to justice in any real sense.
Well, can I just ask you two examples? Take an elderly and infirm person whose income is rent received from a property which she has let, occupied by a well-heeled and intelligent tenant who knows that she can't afford to sue him, and who therefore, without disputing the rent, just doesn't pay it. Now, when she goes to court, is she not getting access to justice?
The point there, Lord Briggs, my lord, is that there's a denial. It's important to be clear. When I say a dispute arises as a matter of substance, not of form. I'm not saying that a dispute only arises where a claim is denied in a defence or in an honourable service. In the example which my Lord Briggs has given, the landlord has, in substance, denied. He's not paying the money that he's due to pay. That's the example you're giving. So the dispute is crystallised because he is refusing to pay, and that's the dispute. And if a solicitor is instructed that, if a solicitor is brought in at that stage, even if the solicitor writes a letter saying at that stage you are refusing to pay, if you haven't got a justification, we will issue a letter for action. We acknowledge that's a dispute, and the solicitor's work at that stage is covered by the solicitor's lien because there is a dispute. If subsequently he writes a letter for action, the process continues. If it's settled at that stage, again, we accept there's a dispute and the equitable lien applies. It's a question of form, not substance. But there has to be a dispute. There has to be denial of the right.
Thank you. My other example is this. Does it follow from your point that on the evidence, Ryanair now has a direct access platform under which people can more easily get paid, that there would be a lien if assume there's another airline that doesn't? Does the existence or non-existence of the lien depend upon whether the defendant airline or other organisation does or doesn't have some convenient direct access means whereby individuals can get paid?
In our submission, no, it doesn't depend on that. But it's a fortiori where the airline does provide that access to payment, and I'll be given the reference. In my understanding, the regulation requires that its terms are enforced and policed by the member states and by their civil aviation authorities. And in order to make that right effective, they are obliged to ensure that airlines do provide a means whereby, or the member states provide a means whereby the monies can be claimed easily and cheaply. And so that may be the answer to Miles' question. But in this case, it's equal to.
Thank you.
If I may then go back to what I was proposing to say to you and engage then with the authorities. I'll take you. I want to set the scene before I go to Gavin Edmondson and show you very briefly Megardiction. And I appreciate it's more than 100 years old, but there are some pearls in it, and at least it describes the law as it stood until Gavin Edmondson itself. And that's in the authorities bundle behind page 985. And I wish to take you to page 986. We're going to make a Megardiction in the High Court first, the judgment of Mr. Justice Rowlett. And the court would be familiar with the facts of this case because they're set out in detail in the judgment of the Court of Appeal. But if you go to page 986, at the bottom of page 986, last paragraph, you can see what was in issue. The defendants, those are the solicitors, had been negotiating on behalf of the syndic, so the trustees in bankruptcy for Ryanair, and they'd obtained delivery of documents from the representatives of Bergheim against a payment of £300. So there was a negotiation, and they got something concrete for their client, and they said the lien should apply over it. And over the page, Mr. Rowlett says, 4 lines down, I can find no authority for a lien of this character upon the fruits of a mere negotiation conducted by a solicitor, nor do I think it can be supported on principle. And then, and obviously he's referring to the equitable lien as we understand it. And then down to the bottom of page 987, he notes Mr. Leslie Scott's argument, and he says that the solicitors by notice could have prevented, if his argument is right, the solicitors by notice to Bergheim's executors could have prevented them handing over the documents to the plaintiff. And I suppose the solicitors, the executors could, by notice to the plaintiff, have established a charge on the £300 and prevented the executors paying it to the plaintiff. And this is in circumstances where what we have is a negotiation. There's no proceedings in any sense. And he says, I think this is a reductio ad absurdum. It would be a remarkable state of things if each party to a bargain, and I would say a transaction for present purposes, were to be hampered in obtaining its fulfilment by questions of costs arising between the other party and his solicitor. For these reasons, I think that the point on behalf of the defence is misconceived. And I'll be coming back to that observation on transactions later. And then over the page, we're now in the Court of Appeal 989 and the judgment of Lord Justice Sfinfanidi. And I wish to take you to 997, where again the same argument is made by Mr. Leslie Scott. And if you go just below the, you haven't got a, you're on a screen. I was going to refer to a hole punch. That's of no assistance to you. It's at the bottom quarter of the page. It begins, now, in my opinion, there is no analogy at all between proceedings of that kind, where the lien would apply, and the lien so acquired, and a case where there are no proceedings, but merely negotiations with regard to a matter and correspondence taking place between the solicitor and either side. And Mr. Leslie Scott claims the solicitor obtained a lien, but he's quite unable to produce any authority whatever in support of the proposition. Case after case, which he referred to, all cases in which there was an action or a suit or proceedings of some kind, they were all cases with regard to proceedings. Not a single case was cited where such a lien is here claimed was ever shown to exist. And then below that, Lord Justice Sfinfanidi refers to the policy consideration. He says that the court's gone to a considerable extent to uphold a solicitor's lien and to endeavour to see that the solicitor having earned costs should be paid. At this point, of course, in history, the solicitor's lien was a well-established and well-developed equitable intervention. He refers even to the fact that Parliament intervened in the Solicitors Act of 1860 to ensure it had a statutory footing. That's what we now see in the Solicitors Act of 1974. But again, that statutory provision, like the current one, refers only to litigation, and in circumstances in this case, no such charging order could be obtained. And over the page 999, Lord Justice Banks agrees and suggests that, although he doesn't say what they are, good reasons why the lien shouldn't be extended to commercial negotiations. Now, the next case I want to take you to before we get to Gavin Edmondson is Glasgow and ELS. That's at page, it's tab 18, forgive me. It's at page 839, Glasgow ELS Law Limited, and I wish to take you, if I may, to 847. And again, although this is only a first instance authority, it does contain a useful summary of the law as it stood before Gavin Edmondson. And the general position is stated on page 847. And just above that, the heading is lien. And you see that in this case, insurers had supported litigation which had been resolved successfully for the insured. There was a substantial fund paid into court, but the successful claimant became insolvent, and the insurers, who would otherwise have been an unsecured creditor, claimed that since they had been instrumental in bringing the case to fruition, ought to have a solicitor's lien, ought to have a lien by analogy with the one that the solicitors would have. And the general position is described from paragraph 42 by the Deputy High Court Judge, and he makes the point it's important to recall by a backer there is no general right to a lien merely because a party has done work or spent money which has preserved or benefited the property of another, referencing the judgment of Lord Justice Bowen in Falk. And my lords and my ladies can read that to yourselves down to the bottom of paragraph 43. And the solicitor's lien is described from paragraph 45. And having made that important point that there is no general right to a lien simply because you've done work, even very important or indispensable work, to gain property for another. An exception to the general proposition concerns a solicitor's lien over a fund of the proceeds of a judgment. Apart from statute, which is the 74 Act we've discussed, a solicitor has a lien which may be actively enforced over a fund or proceeds of a judgment recovered for the client in the course of litigation or arbitration by the solicitor's exertions, but not over the fruits of negotiation without litigation. They are referencing, in my submission, although he doesn't cite it, the judgment in Megadici. And then he describes the nature of the lien, and over the page he references the point again, and my Lord Briggs has this obviously, and Gavin Edmondson also, that it's been recognised since Lord Mansfield and Welsh and Hole in 1779, and there are numerous authorities all the way to the Cairns judgment, which reference the lien, but always in respect to litigation or arbitration. And you have the submission by Mr. Clark at paragraph 50 that the insurers should be entitled to the same lien because their position is directly and closely analogous to that of the lawyers who brought the case to trial. If the court then could turn to paragraph 57, you see why the High Court in that case ultimately refused to extend the lien to insurers in these circumstances. And in my submission, this engages with the point raised by the court earlier. Well, why is it fair to draw the line? One can easily imagine a case where an active litigation insurer could be indispensable for bringing a case to trial with its expertise in class actions, for example, in group litigation or collective proceedings. They may be indispensable in bringing a case to ultimate successful fruition. But the learned Deputy High Court Judge says at 57, there are two reasons why the insurers are not entitled to a lien. He says that first, he refers to the prudential judgment of the Supreme Court. He notes that the issue there was legal advice privilege. The question in that case is whether it should be extended to communications for the purpose of giving or receiving legal advice on tax issues between clients and chartered accountants, not just lawyers. And if you see at 59, the submission made by the appellants in prudential. And then over the page, paragraph 60, the chartered accountant's appeal was dismissed in prudential. And Lord Newberger says this in the indented passage. There's no doubt the argument for allowing this appeal is a strong one. As anyone reading Lord Sumption's judgment, his dissenting judgment can appreciate, it's hard to see as a matter of pure logic why legal advice privilege should be restricted to communication with legal advisors who happen to be qualified lawyers, as opposed to communication with other professional people with a qualification or experience which enables them to give expert legal advice in a particular field. But then at little 2, where a common law rule is valid in the modern world, but it has an aspect of limitation which appears to be outmoded. It's by no means always right for the courts to modify the aspect or remove the limitation in any such case. The court must consider whether the implications of the proposed modification or removal are such that it would be more appropriate to leave the matter to Parliament. And then he says why he thinks it should be left to Parliament. He says that the consequences of allowing the appeal are hard to assess. I made the same point earlier to my Lord Burrows. The question whether LAP should be extended to cases where legal advice is given from professional people who are not qualified lawyers raises question of policy, again for Parliament. And thirdly, where Parliament has enacted legislation relating to LAP, which at the very least suggests it would be inappropriate for the court to extend the law on legal advice privilege as proposed by Prudential. And pausing there, the court has my point that where Parliament has engaged directly with the question of the scope of the actual lien, as it did in section 73 of the 1974 Act, that was restricted to proceedings. And over the page, he makes an important point about the policy considerations that arise from extending the lien, and he refers to insolvency, because he says at 62, any decision the insurers have a lien over the fund would create an exception to the statutory regime for the distribution of the assets of an insolvent debtor amongst its creditors, which in England and Wales is contained in the Insolvency Act. That scheme prescribes, and he quotes, proportionate recovery by all those who are unsecured creditors at the commencement of the winding up, subject to any preferment or deferment of creditors pursuant to particular statutory provisions. But regardless of the moral strength of their claims, and quoting Lord Sumption below that 63, the statutory rules for the distribution of insolvent estates represent an important public policy designed to achieve a pro rata distribution of the company's estate between its creditors. And over the page, if I may, at 65, this is on page 853, and he says, for those reasons, whether the insurers should be entitled to priority, whether they should have the lien, is self-evidently a matter for the legislature. So with that scene setting, if I may, I'll turn to what this court did say in Gavin Edmondson. And that is at page 814. I appreciate the court's been taken to it already, but I obviously place emphasis on slightly different passages from those to which have been taken by my learned friend. Judgments at 814, and I do rely on the introduction of my Lord Briggs at paragraph 1 in describing the long-established remedy known as the solicitor's equitable lien. In its traditional form, it is the means whereby equity provides a form of security for the recovery by solicitors of their agreed charges for the successful conduct of litigation and the fruits of that litigation. A judge-made remedy motivated, and this is important, not by any fondness for solicitors as fellow lawyers or even as officers of the court, rather because it promotes access to justice. Specifically, it enables solicitors to offer litigation services on credit to clients who, although they have a meritorious case, lack the financial resources to pay upfront for its pursuit. It's called a solicitor's lien because solicitors used to have a virtual monopoly on the pursuit of litigation in the higher courts, and this is the caveat we've heard to. Nothing should be read as deciding whether the relaxation of monopoly means the lien is still limited only to solicitors. And we submit that is the key criterion, as the Court of Appeal found in this case. If you go then, please, my lords and my ladies, to paragraph 3, between F and G. There the court said, Lord Briggs says the lien was recognised as a security interest enforceable against the fruits of litigation, again, litigation up to the amount contractually due to the solicitor in priority to the interest of the client or anyone claiming through him. And then at page 823, I'm going to come back to the pages I've skipped, but I'm going to go now to where my Lord Briggs deals with the background to the equitable lien and to paragraph 30, the existing law. And at paragraph 31, and I'm referring to these not just by way of interesting background, but because they do show the principles which form the boundaries around which the remedy needs to be fashioned. So this case law is not simply of historic interest, but provides the rationale and limitation for the principle itself. And we see it first, Reed and Dupper, at paragraph 31, where Lord Justice Kenyon describes the principle that a party should not run away with the fruits of the cause. Of course, the cause means the litigation, the proceedings. There's a dispute where the cause is referred to without satisfying the legal demands of his attorney, by whose industry, in many instances at whose expense, those fruits are obtained. And then at 32, Ormerod and Tate, if you could please get down, Lord Justice Kenyon extended it to arbitration on the basis that such an extension was justified by convenience, good sense, and justice. And in that judgment, Lord Justice Kenyon recognised a particular public interest in encouraging the use of arbitration. Again, then, as Lord Briggs found, access to justice was the key criterion, the key underlying principle for this lien. And two early cases demonstrate that access to justice lay behind the development of the principle at 33. And you see what Vice Chancellor Plummer, forgive me, I don't know how to pronounce that, ex parte Bryant, doesn't want to relax the doctrine, for it is the advantage of clients as well as solicitors. For business is often transacted by solicitors for needy clients, merely in the prospect of having their costs under the doctrine as to lien. Similarly, in Re Moss, Master Rolls said it's of great importance to preserve the lien, It's the real security for solicitors engaged in business. It's also beneficial to the suitors. It would frequently happen, but for the lien which solicitors have upon papers and deeds, a client who is not able to advance money to enable them to carry on business would be deprived of justice through inability to prosecute his claims in the suit. And then at paragraph 35, just below H, the very last line on the page, one sees the reference to refold, where Mr. Justice Scarman, as he then was, refers to the basis for the lien. And Lord Justice Briggs, Lord Briggs, my Lord, refers then to the principle arising from these cases, and he says, provided the debt has arisen in part from the activities of the solicitor, no reason in principle, by formal proceedings must first have been issued. And here we see the extension from the previous practice and previous case law, all the more so in modern times when parties and solicitors are encouraged as a matter of policy to attempt to resolve disputes. So, pausing there, in our submission, our respectful submission, my Lord Briggs here is still referring to proceedings, albeit informal proceedings, required to resolve disputes, even though they may be resolved by suitable forms of ADR, and where pre-action protocols of widely different kinds have been developed precisely for that purpose. That is the purpose of resolving disputes, which would otherwise litigate. And when we rely on that, and I've explained earlier to my ladies and my lords that when we speak of a dispute, to be clear, we're not talking about a dispute that arises only when a claim is acknowledged or resisted in a court or arbitration. A dispute arises where the claim or the right is denied by the other side. That is the crystallization. At that point, we have a dispute, and at that point, justice needs to be accessed for its resolution. And the judgment goes on to consider the Kahns case. Now, my learned friend referred to Kahns in his case, but he didn't refer to it in his oral submissions. And in my respectful submission, that was correct, because Kahns doesn't engage with the issues which are before you at all. It doesn't provide the answer or any guidance. That was a litigation case, so the Court of Appeal doesn't have to grapple with the point that is now before you. It doesn't provide the answer. And paragraph 33 of Kahns, which my Lord O'Briggs cites at paragraph 36, isn't intended to be a compendious statement of the conditions for the lien. As I think my learned friend might have even suggested at the beginning of the day, although he didn't say it came from Kahns. And Kahns was all about notice. It was the question of whether, absent collusion, awareness of the right of the solicitor to his fees would be sufficient. That's what that paragraph addresses, and that provides, unfortunately, no assistance to us today. If I may then go back in this judgment to the RTA protocol, back to paragraph 23, which is at page 821 of your bundle. And this is critical because it demonstrates why, notwithstanding the emphasis in the case law to the importance of proceedings, and as my Lord Briggs said, even informal proceedings in ADR, why the process under the RTA protocol falls on the right side of the access to justice line. And we see that when we examine the terms of the RTA protocol. And if I may, this is my final, I'll deal with this before we finish for lunch, if you'll bear with me. Paragraph 23, the RTA protocol deals with personal injuries between £1,000 but up to £10,000. And my Lord Briggs notes that it's been extended since to £25,000. So one sees right away that although these may be more straightforward than very large-scale personal injury claims in the High Court, they're still claims with a value up to £25,000. And so on a completely different scale from those which are at issue under the Regulation 261. And 24, my Lord says, the protocol describes in great detail the behaviour the court will normally expect of parties, of their legal representatives and the parties insurer. Under the protocol scheme, parties, lawyers and insurers, when required to send information, are expected to do so electronically through the portal established by road accident insurers. And this is an important process. I rely on the fact discussed with the court earlier this morning that the portal is established and managed by solicitor representatives, claimants and defendants. It's a detailed and formal process, like a form of arbitration scheme for the resolution of these disputes. While notice of claims falling within the protocol is expected to be given in accordance with the procedures, not mandatory, however, there are possible cost consequences if qualifying claims are not processed in accordance with the protocol. Over the page 822, the aim of the protocol, and this is important, is to ensure that the defendant pays damages and costs using the process set out in the protocol without the need for the claimant to start proceedings. That is, but this is designed as a substitute for proceedings. But for this, the claimant would be starting proceedings in court. Damages are paid within a reasonable time, and importantly, the claimant's legal representatives receive the fixed costs at the end of each stage in this protocol. And claims that no longer continue under the protocol cannot subsequently re-enter the process. It's initiated by the completion of the claim notification form, the CNF, and that form is vitally important. Now, pausing there, it's said in this case against me that the Bott letter before claim is akin to the claim notification form, and that the work that Bott undertakes is like the work which a claimant solicitor undertakes in advising his client or her client and completing and submitting the claim notification form. And we say not so. If you could just keep the, again, I don't know how many screens my Lord's Majesty have, but I'll come back. I'm going to come back to Gavin Edmondson, but if I may go to the key bundle and just show you what the claim notification form requires. We set out, rather than take you to the authority itself, it's not a dispute what the CNF requires, and it's in our case. It's in the respondent's case at page 80 of paragraph 79. And the requirements in the claim notification form are there set out. It's necessary for the individual, and more usually the solicitor, to provide significant details of the injury, the time the claimant is taken off work, medical treatment which the claimant has received, details of any rehabilitation treatment which the claimant has received, such as physiotherapy or rehabilitation needs following the accident, details of damage to the vehicle and the insurance arrangements in relation to the vehicle, details of any alternative vehicle provisions the claimant has received or requires, full details of the accident, time, location, weather, road conditions, a description of the accident, involvement of the police, details of other parties involved, a statement of why the claimant believes that the defendant is responsible for the accident, and if there's any third party alleged to be responsible, why that is. Details of the funding arrangements which the claimant has in place, other details in certain cases whether it's an MIB claim or an accident involving a bus or coach. And then this, importantly, the whole thing has to be verified by a statement of truth. And that was specifically noted by my Lord Justice Lewison in paragraph 44 in the Court of Appeal. This is really close to originating proceedings in a court or arbitration. And one can see right away, it is very hard to do this without a solicitor. This is a million miles from.
Yes, I'm sorry, we're just about to conclude this. Please conclude it. That's fine.
Yes, and well, that's. I'm going to conclude there, my lord.
Thank you. Can I just leave you with Can I leave you an over lunch question?
Yes.
You were developing the submission earlier that the critical requirement for there to be a dispute is that there's been some denial of a claim. Not necessarily because the claim is disputed, but because, let's say, payment is refused. And my question for you is, which side of that line does the RTA protocol claim form come? Will it qualify as a perfectly good RTA protocol claim form in the absence of any prior denial by the insurer of the claimant's entitlement? Or can it simply be the first communication of a demand to the insurer? Thank you. Don't answer now, but I was just trying to apply your earlier submission to this particular type of process.
I understand. I have an answer, my lord, but I'll give it to you after lunch.
Thank you very much. We'll adjourn until 2 o'clock.